Hey guys, what's going on? Today we're going to talk about power of attorney versus executor. Hi, my name is Attorney Edward Littlejohn, and I'm the founding attorney and CEO of Littlejohn Law. We are the Ohio real estate and probate law firm. Today I'm going to go over executors versus power of attorney, and I'm going to separate fact from fiction. Far too often people think that power of attorneys and executors kind of the same thing. They have similar duties, but they think their function is the same way. And so that's what I'm here to do. I'm here to provide the clarity on the two different designations. So the first thing I want to talk about is what is a power of attorney? A power of attorney is a legal document. Looks like we got a couple viewers coming in. Hey guys, how's it going? I'm just going to go over the power of attorney and the executor. So like I was saying, the power of attorney is a designation where somebody allows you to make decisions for yourself. So in other words, I can designate somebody else to be my healthcare power of attorney, so they'll make healthcare decisions for me. I can designate somebody else to be my financial power of attorney. They will make financial decisions for me. Now, that's very similar to an executor. However, the power of attorney only works during life. Once someone passes away, then we need to look at the executor. And so I think that's the number one distinction that everyone needs to know about is power of attorneys are during life, while executor is after death. Now, a lot of our clients are concerned with their power of attorneys, and they're saying, hey, I don't want to designate somebody to be able to make decisions, go to my bank account, take all my money and stuff, because I'm fully capable of doing that. In that instance, then our team would create what's called a springing power of attorney. What that means is the power of attorney only goes into effect at the time when you're incapacitated or you can't make decisions on your own. So it springs into action. The key is that you have to have these documents in plan before you need them. The other thing that's very important is the financial power of attorney. It could be springing too. But what about when someone passes away? What happens then? When somebody passes away, we need to find out who's the executor under the will. Now, the executor is a person who's responsible for gathering all the assets of their loved one. They're going to be responsible for paying all the bills. They're not personally liable for the bills, but they're liable on behalf of the estate. So in other words, if a bill comes to the estate, the executor has to pay that bill on behalf of the estate. So again, the power of attorney duties, responsibilities, functions only apply during life. Once someone passes away, we have to look at an executor to do the same thing. So if I'm designated as somebody's financial power of attorney, I can access their bank account during life. I can pay their bills during life. When they pass away, we have to look at the will to see who has been labeled their executor. If I'm their executor, then I can continue paying bills. The only difference is the bills would be paid on behalf of the estate. The other thing that commonly comes up is, well, what can an executor do and what can't an executor do? Well, when you look at your will, you're going to want to see the specifics. Really good drafted wills will lay out a lot of specific duties that an executor can handle. In the event that it doesn't specify the specific task that the executor wants to handle, then the executor won't be able to do it without the probate court's permission. So a couple of years ago, my team and I were working on a case. A guy had passed away. His uncle had passed away, I should say, and he was labeled as the executor in the will. And so he wanted to sell his uncle's property because the uncle had signed a purchase agreement, died before the sale was complete. And so the nephew wanted to complete the sale. The probate court immediately wanted to halt the sale on the basis that they didn't know what the will said. We had to present the will to the probate court so they could see the specific power that authorized the sale of the real estate prior to the court approval. So if you want it to be easy on your loved ones, right, you're going to want to make sure that your will has a lot of information on what my executor can and can't do. Can they sell a piece of property before they get to court order, right? It's not a bad thing if they can sell it beforehand. It's not a bad thing if they have to wait. You know, it's just all very time sensitive. Some of our clients, again, they have started the sale of the process with the deceased. So the deceased person signed the purchase agreement, closing date is set, and then their loved one passes away. And so they want to be able to honor that purchase agreement. If they're not able to honor the purchase agreement, then the probate court would step in. The only issue is that it takes time, right? The probate court takes time. They have to make sure that everything's properly processed before they do anything. So that's really the biggest difference between the healthcare power of attorney, financial power of attorney, and the executor is when the duties and functions take over. So another question that we have is, well, is the executor liable? And the answer is no. An executor is not liable for anything that they do as long as the will states that there's no liability. Now, one caveat to that is that an executor must safeguard property. So if you're labeled as an executor and you have real estate or you have some sort of stocks or something, you're going to want to make sure that you maintain the value for the estate. So if it's a piece of real estate, you can't let it get dilapidated. You can't let it get torn down. You know what I mean? You can't allow waste to occur. So if you do, then the beneficiaries could come after you for liability because you have devalued the estate. Now, again, my team and I regularly handle estate plans and probate. Estate plans before life, probate after death. So the key is you want to work with somebody competent, somebody who knows how to do this. And this is what my team and I do. We do real estate and probate. That's it. So we take very good pride in what we do, and we make sure that this is as easy on our clients as possible. Before we end, David, did you guys have any questions?
Hi, how are you?
I'm good. How are you doing?
Good.
Uh-oh.
Oh, there we are.
Okay, great.
No, we don't have any questions. We were just.
I do have one question.
Go ahead.
And this is kind of how are the people that stand to inherit something?
Right. So that's a great question. How do we notify the beneficiaries under a will, and who notifies them? That's the executor. That's the executor. The executor will notify the beneficiaries under the will once the estate is opened up. There are certain forms that have to be filed and submitted, notifying that executor about their duties and responsibilities, but also notifying the beneficiaries that they won't inherit until we get an order from the probate court, but that they are legally entitled to something. If you guys have any questions, feel free to give us a call. We're here to help you make a well-informed decision. And remember, where there's a will, there's a way. And where there's no will, then there's probate.